Good afternoon, everyone. Thank you for joining us today. My name is Rhiannon DiClementi, and I'm a staff attorney in the Employment Unit at Community Legal Services. Welcome back to Worker Wednesdays. We're happy to be here with you today and to share some information about workers' rights during the current public health crisis. Our hope is to have these sessions on a regular basis, so if there's any issues or concerns that you have, you can note them in the comments below, and we'll try to address them in some of our future sessions. If you have any questions about today's presentation or the topics we cover, you can go ahead and put those questions in the comment box below, and we'll attempt to address them at the end of today's session. I'm joined today with my colleague, Liz Sultan, who's also a staff attorney in the Employment Unit at Community Legal Services. So today we're going to be discussing a few issues that are relevant to workers who are either out of work due to coronavirus or still working. And we're going to go ahead and cover paid sick leave, paid family and medical leave, health insurance, eligibility for folks who have been laid off, and other benefits that are currently available, and also some return to work issues that are popping up as businesses begin to open and stay-at-home orders are being lifted. So I'm going to kick things off talking a little bit about a new federal law that provides paid leave for workers related to COVID-19. So this law is called the Families First Coronavirus Response Act. It was passed by Congress in April, and it does two main things that I'm going to talk about here today. It creates emergency paid sick leave for workers who need to take time off for reasons related to COVID-19, and it also expands the Family Medical and Leave Act to provide partially paid leave for workers who are unable to work because of childcare reasons. The FFCRA applies to employers with fewer than 500 employees. So you may not be covered if you work at a very large employer that has more than 500 employees working. It applies to both full and part-time workers, regardless of your immigration status. So if you're on a work visa or you're undocumented, you may still be eligible for leave under the FFCRA. One thing I'd like to note is that there is an exemption to these leave laws for certain healthcare providers and emergency responders. The regulations contain a broad definition of healthcare providers. So this includes not only medical professionals like doctors and nurses, but also other workers who are needed to keep hospitals and similar healthcare facilities well supplied and operational, and also workers who are involved in research, development, and production of equipment, drugs, vaccines, and other items needed to combat COVID-19. Similarly, the definition of emergency responder is also broad. It includes anyone necessary for the provision of transport, care, healthcare, comfort and nutrition of patients, or others needed for the response to COVID-19. This isn't an automatic exemption, so if you fall under the definition of healthcare provider or emergency responder, you may still be entitled to leave, but it's discretionary on the part of your employer. So if you're a healthcare provider or emergency responder and you have questions about eligibility for leave, you can always reach out to CLS and we'd be happy to talk through these issues with you. So first, I'm going to talk about emergency paid sick leave under the FFCRA. This law gives eligible workers 2 weeks of emergency paid sick leave if you're unable to work for reasons related to COVID-19. The 2 weeks, it's capped at 80 hours for full-time workers. If you're a part-time worker, the amount of hours you get is going to be based on your regular schedule during a 2-week period. So just a simple example, if you normally work only 15 hours a week and that's your regular schedule, you're going to be entitled to 30 hours of paid emergency sick time under the FFCRA. So emergency paid sick leave is either going to be fully paid at 100% of your regular rate, or it's going to be partially paid. The easiest way to understand this is that it's going to be fully paid if you're taking leave for reasons related to your own health, and it's going to be partially paid or taking leave for reasons related to care for another person. So, sorry, let me just pull up my next slide here for you. So again, it's going to be paid at 100% of your regular rate. It's capped at $511 per day. If you're unable to work because you're subject to a local quarantine order or another government order that essentially prohibits you from working, if you've been advised by a healthcare provider to self-quarantine, so an example of that might be if you have some sort of health condition that puts you at higher risk if you're exposed to COVID-19, and you have a note from your healthcare provider recommending that you not return to work because of that health condition, you could take leave for that reason. And finally, if you're experiencing COVID-19 symptoms and actively seeking a diagnosis, so that you're trying to go to the doctor to get a COVID-19 test, you're awaiting test results, things like that, those types of situations, you're going to be able to use this emergency paid sick leave and recoup 100% of your wages during that leave period. As I mentioned, if you're taking leave to care for another person, you're going to be paid at 2/3 your regular rate. That's capped at $200 per day. And that's if you're unable to work because you're caring for someone who was quarantined due to a governmental order, you're caring for someone who's been advised by a healthcare provider to self-quarantine, or you're caring for a child whose school or care provider is not operating or closed down due to COVID-19. The regulations to this law make clear that the individual that you're caring for must be an immediate family member who resides in your home. So that's just one thing to note. So in addition to this 2 weeks of emergency paid sick leave, the FFCRA also has expanded the Family and Medical Leave Act, which many of you may be familiar with, to give workers partially paid leave if they need to take additional time for childcare purposes. So under this expansion to the Family and Medical Leave Act, if you're unable to work because you have to care for a child who's at home because their school or care provider is closed because of COVID-19, you can request additional leave. So like the FMLA, this is 12 weeks of partially paid job protected leave. The first 10 days are unpaid, but of course you can use that 2 weeks of emergency sick leave that I just discussed so that you get paid during the first 2 weeks. Then the next 10 weeks, if you need to take additional time off for childcare purposes, you can do so under this expansion to the FMLA, and you're going to be paid at 2/3 of your regular rate for those following 10 weeks. There is one additional requirement for eligibility for this expanded FMLA leave, and you must have worked for your employer for at least 30 days. So you have to have been on the payroll for 30 days before you can use this expanded FMLA leave for childcare. There are a few special concerns under the FFCRA that I wanted to make you aware of. The first is that leave under the FFCRA is an addition to any other leave you have under other laws, some of which Liz is going to touch on shortly, or under your employer's policies. So for example, if you have 10 paid vacation days under your employer's policy, you would still retain those 10 vacation days in addition to any leave that you're entitled to under the FFCRA. Most notably is that your employer cannot force you to use any other paid time off that you have before taking leave under the FFCRA. So going along with my last example, your employer can't force you to use your paid vacation days before using your 2 weeks emergency sick leave under the FFCRA. So that's good for workers because you might be able to save some of your paid time off days and instead use leave under the FFCRA if you're unable to work for reasons related to coronavirus. Another note is that if you've been furloughed, laid off, or your work site has closed due to coronavirus, you're not eligible for leave under the FFCRA. If that's the case, your business that you work for has closed down, or if you've been laid off, we recommend that you apply for unemployment benefits or PUA. And you can find more information about that on CLS's website. And finally, another special concern is that your employer is not required to pay you for any unused FFCRA leave if you're laid off. So sometimes under your employer's policy, perhaps you get paid out any unused vacation days at termination. That's not the case under the FFCRA. If you haven't used your 2 weeks sick leave before you're laid off, you do not get paid out for that time under this law. Another note that's specific to the child care leave under the FFCRA is that certain small businesses may be able to claim an exemption from the requirement to provide leave for child care purposes. So this exemption applies to small businesses, meaning businesses with less than 50 employees. It's a narrow exemption, so your employer has to determine whether providing the leave to you specifically would threaten the viability of the business. Your employer is required to document its determination. If you run into this issue where you're requesting leave for childcare purposes and your business is claiming that they're exempt, your employer is claiming that they're exempt under the small business exemption, you should definitely reach out to CLS and we can help you think through this issue and try to negotiate with your employer. So if you need to take leave under the FFCRA, we recommend that you tell your employer as soon as you know that the leave is needed, preferably in writing, and make sure that you tell them, the dates that you'll need the leave, and make clear that you're unable to work due to one of the covered reasons that I previously discussed. Under the law, your employer may request limited documentation. That documentation may include the name of the school that's closed or your care provider that's unavailable due to COVID-19, and a statement from yourself saying that no other care is available for your child, or the name of the healthcare provider that's advising you or a family member to self-quarantine. It's not the typical kind of medical documentation that you would need for regular FMLA leave. It's a bit simpler than that because of the emergency situation that we're in right now. If you're denied leave under the FFCRA, we advise that you contact CLS for assistance or advice. Our intake is open right now, and the number is up on the screen, 215-981-3700. We can help negotiate with your employer, help you draft a letter, or just figure out whether or not you're entitled to this leave. You can also report any violations of the FFCRA to the U.S. Department of Labor's Wage and Hour Division. They have a Philadelphia office. The number is there that you can call. You don't need a lawyer. You don't need to go through CLS if you want to do that on your own. And workers may have a private right of action to bring a lawsuit in court, even though the courts are closed right now, which is limited in some cases. But you should definitely start out, if you're having any trouble getting this leave, by contacting CLS for help. So now I'm going to turn it over to Liz to talk a little bit more about other leave available to workers.
Thank you so much, Rhiannon. So if you could, thank you. So first I'm going to talk about Philadelphia's Sick Leave Ordinance. This is a law that existed before the COVID-19 crisis, and it's been expanded to cover COVID-related reasons for needing to take a leave. Unlike the FFCRA, you need to accrue leave under the Philadelphia Ordinance. So you can get up to 40 hours of leave, which this ordinance applies if you are working in Philadelphia for at least 40 hours in the last year. The leave is paid if your employer has 10 or more employees. It's unpaid if there are 9 or fewer employees. And the way it works is you earn 1 hour of sick time for every 40 hours you worked. And it's supposed to be the employer's responsibility to keep track of how much Philadelphia sick leave you have available. You have to have worked at the employer for 90 days prior to taking the leave. So that's another contrast to the federal leave, which you can use right away. So you can use this leave if you're sick, if you're high risk for COVID-19, if a family member is sick or high risk, or if your child's school or daycare has shut down. This leave is supposed to be paid out before you're laid off. So if your workplace shut down or laid you off, they should be paying you out for the time that you had earned under this law. If you have trouble taking this leave or getting paid out for it upon a layoff, you should contact CLS for help or the Philadelphia Mayor's Office of Labor. Rhiannon, if you could go to the next slide for me, please. Thanks. So the next leave I want to talk about just briefly is Family and Medical Leave Act leave. So again, this is a law that's not specific to the COVID emergency. This provides unpaid leave. So this is something that you might want to use if you or a family member are still too sick to return to work after using up paid leave that's available under the other laws that Rhiannon and I covered. It provides up to 12 weeks of unpaid job protected leave. There are a lot of limitations on eligibility. So we would encourage you to ask your employer about taking this leave, check your employee handbook for what it says about Family and Medical Leave Act coverage. And if you're denied or if you're having trouble taking this leave, that's a situation where we would really encourage you to contact CLS for help. One important thing to keep in mind about taking a Family and Medical Leave Act leave when you're weighing your options is that this allows you to keep employer provided health insurance if you have it. So if you're considering whether it makes sense to quit and go on to try to access unemployment compensation or pandemic unemployment assistance versus keeping your job and your employer provided health insurance under FMLA, that's something to keep in mind. So on that note, if we could go to the next slide, please. I want to talk about what you should do if you lose health insurance through your job. So if you've lost health insurance, you should apply for Medicaid, which you can apply for online via Compass at the website listed here. Or if you think that your income is too high for Medicaid, you can apply for the Marketplace, which would be at Marketplace, at healthcare.gov at the website listed here. We are encouraging people to really move quickly to apply for Medicaid or the Marketplace. An application for one becomes an application for the other, depending on if you don't meet the income requirements for free health insurance coverage through Medicaid. But to get Marketplace coverage, you have 60 days from the day you lost coverage from your employer. So that deadline might be coming up for people who lost coverage in March. You may have gotten a COBRA notice from work, but it's important to remember that COBRA coverage is not your only option. And that's really not going to be the best option for most people because COBRA has very expensive premiums. And you might be surprised that you are covered under Medicaid. So the income limits for Medicaid are higher than you might think. They're around $2,500 a month for a family of 3. And then for those of you who have children, keep in mind that kids can be eligible for CHIP, which is a cheaper insurance option for kids, even in families with higher incomes. So incomes of up to $45,000 a year. For a family of 3, kids could get free coverage, or subsidized coverage for a family of 3 is available if the family is making even up to $65,000 a year. A really helpful organization when you're trying to sort out your health insurance options between Medicaid or the Marketplace or other options that might be available is an organization called FAN, the Pennsylvania Health Access Network. They can help you sort out these options, and their phone number is listed on the slide. If I could have the next slide, please. So I also just want to mention that everyone should keep in mind that if you've lost work or lost hours, you can be eligible for benefits to help with food costs, and also potentially for cash assistance through the County Assistance Office. You can apply online, or you can call Benefili at the number listed here for help applying by phone. Just remember that, for instance, for SNAP coverage, that's help paying for food, you might be able to get up to $509 a month for a family of 3. The amount you get depends on your income, and you can be eligible even if you have, for example, up to $2,311 in income monthly for a family of 3. And then on the next slide, I want to highlight a really important program that is new and is only available for a limited time. So this is the Emergency Cash Assistance Program. You can apply online at the specific link provided here. This program is only available between May 11th and June 12th, or it might close down sooner if the available money runs out. This is only for people who live with a child who's related to them and is under 18, or for people who are pregnant. You have to have been working on March 11th, 2020, and you have to have lost a minimum of 50% of your income, which would count if you've lost your job entirely, of course, due to COVID-19. You should keep in mind that there are income limits on this program. For a family of 3, the household income must be below $2,715 a month, but this gives you a one-time payment of the equivalent of 2 months of the normal cash assistance benefit. So for a family of 3, you could get a one-time payment of $806. And we're especially recommending applying to this program for people who would be eligible for unemployment compensation or pandemic unemployment assistance because they were working, but are waiting for those benefits to come in. So this is something that we're really encouraging people to apply for as soon as possible. Keep in mind also that if your income is very low, you might be eligible for ongoing cash assistance. That's a program that gives you benefits each month, but the benefit amounts are low and your income has to be very low. So the benefit amount for a family of 3 is $403 a month for ongoing cash assistance, and your income to qualify has to be below that amount. And again, that program is only for people with a child in their household under 18 or who are pregnant. There's no cash assistance available for people who don't meet those qualifications. That's all I have to say. I'm going to turn it back to Rhiannon to talk briefly about return to work issues.
Thanks, Liz. So I'm going to wrap up today's Worker Wednesday by talking briefly about some return to work issues that we here at CLS have been hearing about from workers who are now being called back to work, perhaps because their employer has received a small business loan that's going to help them reopen and put people back on payroll, or as stay-at-home orders across the state are gradually lifted. The main concern here that a lot of folks are having are about whether it's safe to return to work, or if they have some sort of health reason that might still be preventing them from returning to work, whether they can refuse a job offer and still continue to receive unemployment benefits, whether that's regular unemployment or pandemic unemployment assistance. Generally, in normal times, if you are on unemployment and receive an offer to return to work, you have to accept a suitable offer or you risk losing your unemployment benefits. So here, it's going to be the case that if you're offered to return to work right now, you could be denied UC benefits if you refuse to return to work unless you have a good cause reason for doing so. So some of those good cause reasons for not returning to work right now can include a lot of things related to COVID-19. For example, it could include being at higher risk for severe COVID-19 related illness. So if you or a family member has some sort of underlying condition like diabetes or chronic respiratory condition that puts you at high risk, you're gonna want to get a note from your doctor and make your employer aware of that. Another example could be being asked to work at a business that is open in defiance of the PA governor's stay-at-home order. I'm sure most of you are aware that the stay-at-home order isn't being lifted all at once for all counties in Pennsylvania. It's being done piecemeal, and only a handful of counties have moved to the yellow phase at this point. Still under a stay-at-home order and your employer is not a life-sustaining business, but they're opening anyway in violation of that order, you do not have to accept an offer to return to work. If you refuse an offer in that situation, you're not going to lose your unemployment benefits. Another example could be being asked to work at a work site that's not following the health and safety guidelines and requirements under federal and state law, or because you lack childcare. So as you know, a lot of care providers are still closed. If that's the case and you don't have childcare options right now, you may have good cause to refuse an offer to return to work and should be able to retain your unemployment benefits. One thing I'd like to note that in any case, our advice is always that you address these issues with your employer before refusing an offer to return to work. You could talk to your employer. We always recommend that you try and get something in writing because that can always help if there's a dispute later. You should let your employer know about any of your concerns, whether they're health related, safety related, or childcare related. Give your employer a chance to respond. They should be working to accommodate you to find out whether there's a way you can work remotely or find some other solution. But if there's not a safe way for you to return to work right now because of one of these concerns, you may have good cause to refuse an offer and should remain eligible for your unemployment benefits. Again, try and do this in writing if you can, email or a letter, and try and save all communications with your employer in case there's a dispute and that evidence could be helpful later for the UC agency. If you're still in touch with a lot of coworkers, I know a lot of people are out of work right now, so it might not be that easy to talk with your coworkers, but if you do and coworkers share similar concerns, you should try and act together as a group to address any concerns with your employer. This could be by sending a group email or a letter or a petition about health and safety at the work site, childcare for employees. By acting together, you have additional legal protections against retaliation under the law. So if this is a possibility, we always recommend taking this approach. In any event, if you refuse to return to work because of one of the reasons that I just discussed, you're not going to automatically lose unemployment benefits. This will always be, it will always be done on an individual basis, a determination made by the state unemployment agency. It's a case-by-case basis. They'll look at the specific facts of your case, which is why it's so important to have some evidence, some written communications if you can. You'll keep if you're currently receiving unemployment benefits, you're going to keep those benefits while your case is reviewed. But we just want to make people aware that there's always the risk that you may lose benefits or be assessed an overpayment in these situations. But there's a lot of misinformation out there right now. And we want to make clear that if you have concerns about returning to work right now, whether they're related to your health, a family member's health and safety conditions at the work site, or childcare, you may have good cause to refuse to return to work, and you may be able to keep your unemployment benefits. And I think that's important information for folks right now. If you have any concerns or questions about returning to work, you can always reach out to CLS and we can help you think of ways to address these issues with your employer and try and find an accommodation. So that was a lot of information for today's session, but I want to end by letting folks know that our phone intake is open. The number's right up here on the screen. If you have any questions about any of the issues we talked about in today's presentation or other employment issues that you're facing right now. If you want more information about your rights during the current public health crisis, I encourage you to visit our website. If you go to the website here, /coronavirus, there's a lot of information for workers related to your rights right now, whether it's paid leave, health and safety, or health insurance benefits. You can find all of this information on our website. So now I'm gonna take some time to look through some of our questions and answer them directly. So our first question was from someone who works in childcare and has a pre-existing condition and whose child has a condition that puts them at high risk if exposed to coronavirus. They're wondering whether they can get a doctor's note and still be allowed to collect unemployment if they don't return to work for these reasons. As I just discussed, I think, if you have some sort of underlying health condition that puts you at high risk if exposed to coronavirus, or a family member does, someone that you live with, you definitely want to get a doctor's note saying, that you have this condition that puts you at high risk if exposed, and that your doctor is recommending that you not return to work at this time. If you have that note, you explain the situation to your employer. They should try to find some accommodation for you, whether there's some sort of leave that can be used. If you refuse to return to work for that reason, they're not able to accommodate you, then you should remain eligible for your unemployment benefits. Liz, I think you're muted. Folks can't hear you.
Sorry about that. So the second question that we have today is from someone who's a visiting nurse and working as an independent contractor, and wondering whether, as an independent contractor, she can collect unemployment compensation. So that brings up something that we discussed on our Worker Wednesday last week, and we're not going into it in as much detail this week, but viewers should be aware that there's a program called Pandemic Unemployment Assistance that's available for people who don't qualify for normal unemployment compensation. That includes independent contractors, gig workers, and self-employed people. We're really encouraging those folks to apply for that, and you can find the application online at uc.pa.gov.
So our third question is whether we have any idea when Governor Wolf will be reopening daycare centers in Delaware County. Unfortunately, I do not know the answer to that question. I would suggest that you go to pa.gov. There's a lot of information about the governor's orders there, but I do not know the answer to that question at this moment.
Next question is about someone who is going to be unable to return to work after a maternity leave because of lack of childcare, and who doesn't have an option to work remotely. So this person is working for a home health care agency, so they could potentially qualify for paid leave due to lack of childcare under the federal law, the FFCRA, although their employer may claim an exemption as a healthcare provider. They also might qualify if they work at least 40 hours a year in Philadelphia for paid leave for up to 40 hours due to lack of childcare under the Philadelphia Paid Sick Leave Ordinance. And if they do end up getting furloughed or laid off or having their hours reduced, they could apply for unemployment compensation and likely be eligible on the basis of good cause for lack of childcare. Unfortunately, those are the only options that I can think of right now. Rhiannon, do you have any other thoughts on that question?
No, that sounds right to me, Liz. So our next question, someone commented that they work for the government and they're making it mandatory that this person goes back to work, but they lack childcare at this time. They're wondering what their options are. So your employer may be covered by the FFCRA. It does apply to both private and public employers, but like I mentioned, there is that 500 employee threshold. So if there's more than 500 employees at this business, if there's more than 500 employees, they may not be covered. I would recommend reaching out to CLS, calling our intake. We might just need a bit more information to figure out whether you'd be covered by the FFCRA, which would provide you with up to 12 weeks of partially paid leave for childcare. If you're not covered by the FFCRA and there's no other leave available to you, you might be eligible if you're not able to work and you have to quit, you might be eligible for unemployment benefits.
The next question is about someone who works in childcare in Delaware County and has a child who comes to work along with them, and that child has upper respiratory issues and has had RSV in the past, and they're wondering about getting a doctor's note about not going back when they reopen and collecting unemployment. Yes, the best option here is to work now on getting a doctor's note about your child's condition and the fact that they're at high risk. It sounds to me from the question like you might be collecting unemployment now. And as Rhiannon said, you will be able to still collect while a determination is made about whether you have good cause about not returning to work. We think that under circumstances like this, where you have documentation that someone in your family is high risk for complications from COVID, that's likely to be considered good cause so that for not returning to work, so that you could keep collecting unemployment. But that decision is made on a case-by-case basis. Again, this is the situation. I see that you're working in Delaware County. If you're living in Philadelphia, you might consider reaching out to Community Legal Services for help. Or if you're living in Delaware County, you could contact Legal Aid of Southeastern Pennsylvania.
So our next question is a question related for what happens if you've used up all of your PTO, and then I'm assuming this is a child summer camp calls and says that your child can't return until they're clear of symptoms. So if you've used up all of your PTO and you still need to take time off of work for childcare, you should be eligible. If you meet the eligibility requirements under the FFCRA, you would be eligible for up to an additional 12 weeks of partially paid leave for childcare. So like I mentioned, that's at 2/3 your regular rate of pay. It doesn't matter if you've used up all of your existing PTO, the FFCRA leave should still be available to you, assuming that your employer is covered by the law. So yeah, if a summer camp is closed and your child's staying home over the summer and you need to stay home and care for them, you should be able to use FFCRA leave for that reason, even if you've already used up all of your existing PTO under your employer's policies.
It looks like that's all the questions we have. Maybe I'll give it one more moment to see if any final questions come in. Okay, well, thank you so much for joining us for Worker Wednesday this week. As Rhiannon mentioned, CLS phone intake is open. You can call us at 215-981-3700. We're also encouraging you to check out CLS's website at the link below, including information specific to workers' rights and coronavirus. Rhiannon, did you have anything else that you wanted to say before we sign off?
No, thank you everyone for joining us today. Like I said at the beginning, if you have any kind of topics that you'd like us to cover in future sessions, just drop us a note on the Facebook comments here, and we will try our best to address those issues as we go forward with our future Worker Wednesdays. So thank you for joining us, and we look forward to speaking with you again.
Thank you.